Good morning, everyone. This is the third in our series of five morning employment seminars on various employment topics that might affect you and the workplace in which you work. We are going to be addressing a number of issues today. The three speakers are Peter Montine, Maria Hodgins, and Medora Mariso. And we've divided up the topics amongst the three of them. Peter will be talking about the Seattle Ordinance, which was recently passed, that addresses the subject of independent contractors. And although it is an ordinance that applies to those of you who have facilities in the city of Seattle, in fact, the issue of independent contractors has been a topic of high priority for not only the city of Seattle, but the state of Washington and also the federal government. The objective of all of these entities is to try to make it more difficult for employers to call workers independent contractors. And there are many reasons for this. Obviously, independent contractors don't enjoy the protection of some of the employment laws that employees do. Unions are not entitled to organize independent contractors. They can only organize employees. And there are also revenue issues that are related to the classification of employees as independent contractors as opposed to employees. So it's an issue that is of importance to everyone, whether you are in the city of Seattle or not. And what you're seeing in the city of Seattle really is something you'll see in other jurisdictions as well in the near future. Peter will also talk to you briefly about the changes in various wage thresholds that apply to people who clearly are either exempt or not exempt employees, and also to non-compete agreements. And after Peter, Maria will talk about recent developments with respect to the new wage requirements that all of us are facing across the state. And you might recall that in November, we did have a presentation on this topic, but at the time, the Department of Labor had not yet issued any guidelines regarding the Equal Pay Opportunity Act and how it was to be enforced and applied. And roughly 2 weeks after we had that initial seminar on this topic in November, the guidelines were published. So Maria will have an opportunity to tell you about the guidelines and how they might impact some of the decisions and practices that you might have. Maria will also talk about a new case in the state of Washington that talks about religious accommodations, which we think changes the game plan that some of us worked under before. So that will be of interest to all of you, I'm sure. And finally, Medora will be batting cleanup and talking about an array of different issues that have arisen over the past year. And we'll be giving you some guidelines about how to deal with them. And this will be practical advice for you on how to think through various issues that have popped up and how to deal with them. So with that, I'll turn it over to Peter.
Thanks, Rick. Good morning, everyone. My name is Peter, and this morning I'm going to be talking to you about independent contractors. As Rick mentioned, this is a timely topic because Seattle recently amended its Seattle Municipal Code to add additional requirements for independent contractors working in Seattle. And so this is important to keep in mind because it's about where the contractor is working, not limited to where the contracting entity is. And it covers contractors who are doing any amount of work in Seattle. The new codes call out that, just traveling through Seattle is not enough to qualify as doing work, but pretty much anything above that threshold is going to qualify these contractors for these protections under the Seattle Municipal Code. And so the three main changes that were made to the code regarding independent contractors in Seattle are pre-contract disclosures, payment and payment disclosures, and notice of rights. So the pre-contract disclosures are required disclosures that a contracting entity must provide to a contractor before their work begins. So these are at the outset of the contracting relationship and need to be provided to any independent contractor who is going to be doing any work in Seattle. And these disclosures need to be provided in a single document, so it all has to be in one place. It needs to clearly identify the items listed here on the slide. So you need to include the name of the independent contractor and the name of the contracting entity, as well as the contact information for the contracting entity, a description of the work to be performed by the independent contractor. And I'm guessing that they're going to want something more than just providing contracting services. So some level of specificity in there, as well as the location of where the contracting work is going to be performed. Obviously, this will be important for the Office of Labor Standards to determine whether the contracting work is covered by these new requirements. In addition, the pre-contract disclosure needs to include the rate of pay for the contracting work, the pay basis. So whether it's going to be weekly, hourly, piecemeal, how the payment is going to be made. A pay schedule that includes things like incentives and deductions from pay. The typical expenses that are incurred in this type of work and whether those expenses are going to be reimbursed, and if applicable, what the tip policy is for the contractors. And this information, as well as all the other information covered here, needs to be provided to the contractor in English and in the contractor's primary language if the contracting entity knows that that's something other than English. Now, once the work begins, and the contracting entity is making payments to the independent contractors, they also need to provide them with payment disclosures. These need to be provided at the time of payment and also need to be contained in a single document, need to contain much of the same information as the pre-contract disclosures, including names, description of the services paid for and the location of the services paid for, the rates of pay that affect that payment, any incentive pay or tips included, the pay basis used to calculate that payment, and any reimbursed expenses that are included, and then totaling into a gross payment, all deductions that are being made, and then what the net payment to the contractor is. And again, this needs to be provided in English and in the primary language of the contractor. The other change with regard to payments that the Seattle Municipal Code has made is that if there is nothing in the contract about what the timeliness of the payments is, then the default payment timeline is 30 days. So you can agree to something shorter or longer, but if it's not in the contract, the Seattle Municipal Code now says if you don't agree to it, it's going to be 30 days. And so whenever those payments are being made, whether it's on the default or an agreed to timeline, these payment disclosures need to accompany each payment made to the contractor working in Seattle. The third piece that needs to be provided to contractors is what's called a notice of rights. So this is a set poster created by the Office of Labor Standards. You can find it on their website, and it needs to be provided to all contractors that are working in Seattle that the contracting entity is working with. And this includes contractors that are already under contract. So not only is it prospective, but it's also retroactive. And so if you are a contracting entity and you have independent contractors working for you doing work in Seattle, and you have not provided them with one of these yet, I would strongly advise you to do so as soon as possible. The deadline to do this for already hired contractors was back in September of 2022. So if you haven't done so yet, now's the time. And then going forward, once you begin your contracting relationships, probably at the same time that you're giving people their pre-contract disclosures, you're also going to give them one of these notice of rights. Every time you bring on a new contractor, they get one of these. And so in terms of enforcement of these new provisions of the SMC, as I mentioned, the Office of Labor Standards is in charge of enforcing these new provisions. Not only will they be doing their own investigations, but they've also created a private right of action, which means that contractors who have been harmed can bring their own private lawsuits against the contracting entities. The remedies available to them are any missed payment damages, liquidated damages that are double what the actual damages are, civil penalties, which the amounts have not been disclosed, but certainly something to look out for because they are independent of any actual damages suffered by the contractor, and interest on any of those damages or penalties awarded to the contractor. It's also important to note that these new provisions have a no retaliation clause included in them as well, meaning that if any contractors are trying to voice their rights under these new provisions and there's an adverse action taken against them, that could also create a separate cause of action for the contractor against the contracting entity. And as Rick mentioned, these changes in Seattle are part of a larger sea change in terms of how independent contractors are viewed. And so taking it a different perspective on this and looking at the federal level, there are also some changes on the horizon. The U.S. Department of Labor announced last year that they was going to propose a rule change for independent contractors, and specifically how to determine whether a given worker is an employee or a contractor. And the DOL decided that it was going to return to what's known as the economic reality test to determine whether a worker is an independent contractor or is actually an employee who has been misclassified. This is a test that has been used in various other arenas and has been previously used by the DOL, but there was a departure to just looking at the amount of control the contractor had over their work. But looking to the economic reality test is to look more at the relationship between the worker and the contracting entity in determining how financially dependent and reliant the worker is on the entity, and determining whether that relationship is really in fact an employment relationship. And so the 6 factors that are used to evaluate the economic reality test are here. The opportunity for profit or loss depending on managerial skill, which is basically a fancy way to say how much control or managerial input the worker has over what they're doing. The investment by the worker and the employer, so how much the worker is investing in their own work versus how much of it is provided by the employer. The degree of permanence of the work relationship, whether it's expected to be a continuous relationship or if it has an end date. The nature and degree of control that the worker has over the work they're doing, which was effectively the entire test previously, but is now sort of delegated to just one factor to consider. The extent to which the work is an integral part of the employer's business versus whether it's something ancillary or additional to what the worker normally does. And then the amount of skill and initiative that the worker can put into their work and sort of find their own path versus work their way with the overall goals of the employer. In terms of the process, this new rule change was open for public comment until the middle of December. And now the DOL is looking through those comments and will propose its, the final version of its rule sometime in the near future. No exact date known, but I imagine it'll be sometime this year, and then begin rolling out what that will specifically look like in the employment setting. It's important to remember that this is on the federal level, which means it's determinations of independent contractor under the Fair Labor Standards Act. So whether this affects your contractors or employees depends on whether they are, and to the extent they're covered by the FLSA versus state law and city ordinances. So not necessarily a sweeping change to every single contractor across the country, but certainly something to keep track of, especially to the extent that they're affected by the FLSA. So what should employers be doing with all of this information? The first thing to do is, if you have contractors who are working in Seattle, or you plan on hiring contractors to work in Seattle, you need to start getting your pre-contract disclosures and your pay disclosures ready. You need to look through the requirements, make sure you have all the information prepared so that once you do need to start sending those out, that they're ready to go and you're not scrambling. The Office of Labor Standards has provided some samples for these forms online. You can check them out to get an idea of what they're looking for, but I don't know that they are necessarily a good fit for everyone. So keep in mind that you don't have to follow exactly word for word what these examples have, but again, it's a good idea so you know what OLS will be looking for. And then you also need to make sure that you're providing these notices of rights to all the independent contractors you have who do work in Seattle. Again, including everyone, all the contractors, Seattle contractors that are already working for you. You also need to make sure that you're maintaining records of your compliance with these requirements for at least 3 years. This is what's built into the Seattle Municipal Code, and certainly will help you if and when OLS comes asking you about making sure you've complied with these requirements. You want to make sure you have it all in writing and all ready to go. And then keep an eye on the upcoming changes to the federal independent contractor rule. Figure out which of your contractors, if any, this may affect, and if it's going to affect them, decide what you're going to do about it. May need to convert them to employees, may need to end the contract relationship. Those are complicated questions that your attorneys at Carr Tuttle will be happy to help you sort through. And then finally, as Rick mentioned, I just want to go through quickly some important sort of cost of living changes for 2023 for Washington State. Hopefully you're all passingly familiar with this, but in case you're not, this is a good opportunity to get familiar. So the minimum wage has changed in Washington State, as well as in Seattle, Tukwila, and SeaTac. The asterisk by Seattle is about, depending on the employer size and whether they're contributing to medical plans or receiving tips, that number can change. But those are the base numbers for the minimum wage. Also, the overtime exempt thresholds have gone up in Washington State, and these are higher than those under federal law. So these are likely the ones you're going to be working with. And it's important to keep these in mind, especially for exempt employees who last year were sort of right on the edge of being exempt in terms of their pay. You need to make sure that some of those people haven't gone under the threshold, and if they have, need to decide whether you're going to bring them back up to the threshold or convert them into non-exempt employees. And then finally, the non-compete thresholds in Washington have gone up. So the recent Washington statute on non-compete enforcement sets thresholds, pay thresholds for enforcing non-competes against employees and independent contractors, and require that those thresholds be adjusted for inflation each year. So for 2023, the employee and independent contractor thresholds are here and have gone up, quite a bit in the last couple of years even. And so again, if you had any employees who you were intending to enforce non-competes against who were sort of on the edge of this threshold, please take note that these have gone up and can affect, whether the enforcement isn't an available option anymore. So with all that, I'd like to turn the presentation over to Maria, who's going to talk to you about wage transparency in Washington.
This is Rick, and if I can interrupt for just 1 second before Maria starts. I forgot to mention that at the outset that if you have any questions, use the question and answer function at the bottom of your screen, and we will try to answer as many of your questions as possible at the end of the session.
Thanks, Rick, and thank you, Peter. So as both Peter and Rick at the beginning mentioned, I'll be talking about Washington's new wage transparency law. So this law, which is found at RCW 4958-110, became effective on January 1st, 2023. And so employers should already be complying with it. And if you're not, then, listen up, because we've got some new requirements for you. So the wage transparency law will impact job postings, not just job postings, but also internal job postings. as well as promotions and internal transfers. So for example, if an employee is offered an internal transfer or a promotion within a company, and the employee requests the information, then the employer must provide the wage scale or salary range. So as I said, this also applies to job postings, but there are some things that may seem like job postings, but actually aren't. A job posting needs to list qualifications. So for example, a general help wanted sign outside of a company's storefront is not considered a job posting and does not need to disclose wage and salary information. So the wage and transparency law just requires the disclosure not just of wage scale and salary ranges, but also a description of benefits and other forms of compensation. A question we get a lot is whether the law applies to you. So this law applies to employers with 15 or more employees engaged in business in the state of Washington. Now, note that this 15 employee threshold includes employers who are based outside of Washington, if that employer has even a single employee located in Washington. So for example, an employer may have 15 employees and 14 of them are located in the state of California, and then one of them is located in Washington. This law would still apply. The law also applies to companies that are making nationwide job postings. So for example, opening a job posting to remote workers anywhere in the country. As long as that job posting could potentially be filled by a Washington resident, the law applies and that job posting would need to disclose wage and salary information. The recently released guidance by the Department of Labor and Industries states that employers cannot avoid disclosing wage or salary information simply by stating that the employer won't accept Washington applicants. So this won't get employers out of the requirement. So as I said, job postings require these 3 things. So the first is wage scale or salary range, and I've included some examples. So for example, $60,000 to $80,000 per year or $25 to $31 per hour are good examples of ranges that would comply with the law. Note that these scales or ranges need to be based on an employer's most reasonable and genuinely expected compensation range. So the wage range should extend from the lowest to the highest pay established by the employer prior to posting a job. So if you as an employer don't have a range in mind, you actually need to create one before putting up a posting. Job postings also need to include a description of benefits. This can include retirement benefits, sick leave accruals, parental leave, healthcare benefits, any other fringe benefits that need to be reported for federal tax purposes. And finally, job postings need to include other forms of compensation, such as bonuses, profit sharing, stock options, or even tuition reimbursements. So these are a few examples of what not to post. So 60,000 and up lacks the top of the range, and up to $29 an hour lacks the bottom of the range. So neither of these examples would comply because employers need to provide both the top and the bottom of the ranges. Also keep in mind that, as I said before, the law applies even to remote Washington workers. So even if the employer is based outside of Washington, but the employee is based inside of Washington, then the law applies. Also, as I previously stated, if a salary range doesn't exist, then the employer needs to create one. And other states also have their own wage transparency laws. So if you as an employer are operating in other states, you should be aware of those. Some states include California, Colorado, Connecticut, Maryland, Rhode Island, and some others. This new wage disclosure law is overseen by Washington's Department of Labor and Industries, and violations can result in an investigation. And at the end of that investigation, LNI would likely attempt a resolution. This could include paying back wages that might be owed. And if a resolution isn't found, the employer may face financial penalties. This could include actual damages, the cost of the investigation, and civil penalties. So our recommendations for employers are, first, review job postings, both job postings that are already up, as well as job postings that haven't yet been posted to ensure compliance. And our second recommendation is to review and establish wage and salary ranges for both existing and future positions. I'll also be speaking today about a development in the religious accommodation field. So this is a case law update. There was recently a Court of Appeals decision in Division 3 where a healthcare worker was denied days off that she'd requested specifically for religious reasons. She had previously missed multiple other days of work due to religious reasons, and after she missed additional days, she was terminated and then filed this lawsuit. So the case itself, the court's primarily concerned with religious accommodations in the workplace and the undue hardship standard. So under the Washington law against discrimination, employers must provide reasonable accommodation for the religious practices of its employees. A defense to this is that a religious accommodation can result in undue hardship. So that begs the question, what is undue hardship? Well, this is exactly what the Suarez v. Washington court decided in Division 3. So prior to the Suarez opinion, undue hardship meant only that an accommodation required an employer to bear more than a, quote, de minimis cost. Now, according to Division 3 in Suarez, undue hardship only results when a religious accommodation would cause, quote, significant difficulty or expense to an employer. This new definition promulgated by Suarez is a significantly heightened requirement for employers. This is a bit unsettled at the moment because the case may be reviewed by the Washington Supreme Court, but as it stands now, employers may find it more difficult to deny religious accommodation requests, or if they do decide to accommodate, the accommodation process itself might be a bit more tedious. So this case has the potential to make religious accommodations more complex. In this case, the court applied 10 different factors to determine whether there was an undue burden. These factors should only apply to state employers, but these factors were not used by courts before this opinion. So this is an entirely new procedure that employers will need to use in dealing with religious accommodations. But again, please note that we are uncertain on the impacts of this case, although we should know soon. The Washington Attorney General has appealed the Division 3 ruling decision to the Washington State Supreme Court, but we don't actually know yet whether the court will accept review. So I'm next going to turn it over to Medora Mariso, who will be talking to you about trends and tips for navigating new Washington requirements.
Thank you, Maria. Good morning, everyone. I hope everyone's enjoying the webinar so far. So the cleanup crew, that's my job here. I'm just going to bump through a lot of issues because, gosh, there was a lot of activity in 2022, and there seems to be a lot of things on the horizon for 2023. So some of the things that we're going to talk about in this last section is this emerging focus of bias in the automated employment decision tools. And some of you may not even know what that is, but you may actually be using them. So we'll talk about that. There's also, given climate change and all the issues that we as a human species are dealing with, including in the employment realm, heightened concern by OSHA and I think by also WSHA about heat and smoke hazards in the workplace. And I'll give you some trends and some information about what to look for in 2023. Pay equity continues to be a very big area of compliance for regulators, and I think it's probably going to be one of the new issues that we're going to see in litigation, and just, lots of changes in the pay equity space in terms of compliance. And so I'll give you some tips and trends on that. And no presentation would be complete without a mention of remote work, which just continues, and it's part of our reality now. So I'm going to be talking about leave benefits and leave as a disability accommodation and remote work as a disability accommodation, because I think all of us have dealt with a lot of questions on that. And I think it's important to understand where the trends are. Also, we have meal rest break claims, which everyone, you feel like you know what the law is, and then there's sort of a new twist. And so I'll talk to you about what's kind of happening in that space. And then finally, sort of a related issue is time rounding and pay issues regarding start of day procedures, because there's been some activity in that realm as well. Okay, so what is this automated employment decision tool? So this really comes from artificial intelligence. And the reason why this is even in the presentation is because New York, not Washington, but New York State has a brand new law effective in 2023 that requires any employer who uses these automated employment decision tools to make sure that they are not based on data or algorithms that have implicit bias. And so what kind of things are we talking about? These are like resume scanners that would sort candidates based on what's on their resume. That would be one example. Employee monitoring software that you might use for performance. Something called chatbots, which some tools are being sold out there on the market that are helping evaluate candidate mannerisms. And so the whole concept here is that there's this artificial intelligence that's trying to help employers decide if someone's going to be a good job fit. And you can kind of automatically see why that could potentially be problematic, which is the implicit bias that might be built into those tools and the type of data that they're collecting. Is it really the right data? Is that data going to lead to decisions that are inconsistent with your own hiring policies for diversity, equity, inclusion, or potentially even discrimination? And so what should employers do right now? There's no law in Washington, although certainly we seem to adopt some of the most progressive laws in the country. So I suppose we should be prepared soon for a change. But if you are going to use one of these tools, know how the tool works and what kind of data is being gathered, and evaluate and ask questions. Is that the kind of thing that really is necessary and not discriminatory in terms of your job fit issues? And then also you may need to audit if you are using a lot of these tools. So that's the automated decision tool. Heat and smoke hazards in the workplace. It kind of hurts my heart to even talk about this, but we all went through the summer of 2022, and we realized that out here in the Pacific Northwest, things are getting worse in terms of smoke, wildfire smoke, and heat. And OSHA, which is the federal program, has a new national emphasis on reducing indoor and outdoor heat exposure. So typically, the concept of heat exposure in the workplace has always been for people that work outdoors, like agricultural workers. And there's definitely a lot of compliance action on that. But now more recently, there's been a focus to include indoor heat exposure and smoke exposure. And so OSHA is really, they don't have new rules or guidelines on this, but they are emphasizing. And so of course you have your general duty to make sure that you're providing a workplace that's free of hazards for your employees. And so one thing to think about is what kind of indoor filtration system and heat mitigation you have in your workplace. Oregon in 2022 enacted new heat and smoke rules, which specifically include indoor workspaces. Now, most of us might think, well, I work in an office, so I don't have to worry about it. Here in my building, which I shall not name, there was a problem with the intake during the wildfire smoke, and smoke was being sucked into our building. So I don't know that we ever got to a air quality index that would violate the Oregon threshold, which is 101, but it wasn't good. So those are the kind of things that I think employers now have to be thinking about. And specifically in Washington, currently Washington has two rules. One is the ambient heat exposure and the wildfire smoke. Both of them relate to outdoor work conditions, but they're both going to be updated this year. And so I would not be too surprised if they also included an indoor requirement. So just look for that. Okay, moving on to a completely different topic. Practical tips for pay equity compliance. And so now we have, obviously, we've had pay equity rules for a long time, and now we have transparency. So, which is the reason why, reason for the transparency was to make sure that there is pay equity. And so some of the things that I think there's going to be a lot of activity in focus on this by regulators and maybe those pesky plaintiffs' employment lawyers. So what can you do to make sure that you can you're doing everything correctly and you're reducing your risk of getting in trouble either through a lawsuit or through some complaint? The first thing to do is make sure you're doing an audit. And if you haven't done one already, this is a great time to do it, beginning of the year type of thing, and review all your compensation. Make sure your job descriptions are updated and the compensation is consistent. Identify, this is really important, identify any reasons for disparities in pay. And you might be able to say, well, it's based on the job description, but if really the skill set and the requirements and that sort of thing are not significantly different, you might need to rethink that. Now, L&I does offer free consultation to assess an employer's compliance with the equal pay requirements. There's some good and bad to that. They do also have an employer checklist, which actually is quite helpful. And I think we will be circulating these slides afterwards, and I will add that URL so you can access that. Second thing, so once you've done your audit and you feel like you've been able to understand where your pay is in terms of the requirements, any compensation decision that is entered into should definitely be documented. And it should be documented specifically so that the permissible factors, if there's going to be a difference in pay, are specifically discussed. So permissible factors are education, training, skills required for the job. Make sure those are actual, like they really are required for the job. Geographic differences. So if you have an employee in Seattle versus an employee in somewhere else, then that could be a basis. Seniority. And then there's also sort of a generic category of job-related factors and performance as well. But job-related factors, that's where, this might be a type of position that's really hard to fill. And so any kind of differences like that, you should make sure that that's documented somewhere. Because here's a really important point. It's the employer's burden to prove why the pay difference exists and why it doesn't violate the Pay Equity Act. That's a short sentence, but it's got a big impact. Normally, when we think about someone bringing a complaint like an employee, we think, well, it's their burden to prove we did something wrong. Here, the burden is flipped. So it's the employer's burden to show that they are complying. So it's kind of a different mindset. So a lot more vigilance in making sure that all of these decisions that are being made that result in pay differences are well supported. And finally, which is always just a good idea anyway, but educate managers about the factors they can and cannot use when they're either recommending or improving employee compensation, because it's great if HR understands, but if they're out there talking to employees and promising different salary ranges and everything, we want to make sure that they also have a basis for understanding how they have to comply. All right. Leave issues. The complexity of leave issues just, I mean, it just keeps almost becoming mind-boggling. Here in Washington State, of course, if you have enough employees, you have to comply with the FMLA federal law. You have to comply with the Washington Paid Family Medical Leave. You always have to comply with disability accommodation unless you have fewer than 8 employees. And then there's, paid sick leave, PTO, that sort of thing. And what we're seeing, and people have been navigating this, but what we're seeing now is sort of the confluence of all these things coming together in one leave, and untangling that sometimes can be really difficult. One thing that I think is really important to think about, and I'm going to jump to when can employees stack FMLA and Washington Paid Family Medical Leave. So normally we think about things running concurrently. So if you have FMLA and PTO, assuming your policy provides for it, those would run concurrent. Because the Washington Paid Family Medical Leave Act prohibits employers from requiring employees from applying for that, they can stack PFML and FMLA if they do it correctly. And how they would do that is that they would take FMLA first. Once that's exhausted, then they would apply for PFML, assuming their condition is ongoing. Obviously, if it was for something that's already been resolved, then that wouldn't be appropriate. And then what gets difficult is there might be gaps in when their FMLA and their PFML application is approved, and then they might ask you for a disability accommodation, which might be in the form of a leave, short-term leave. And so you'll have to then engage in a whole different analysis, which is, the interactive process. So these things become very difficult, but I think it's really, really important to make sure you're documenting exactly when, what can be run concurrently, when certain leaves are exhausted. Make sure your policies are updated so that to the extent you can have concurrent leaves, that the policies provide for that. And give us a call if it gets too much. I think I just put in this information about the premium going up for PFML, and not too surprising, I think that just shows that a lot of employees are using Washington Paid Family Medical Leave, and so the costs are going up. Leave as a reasonable disability accommodation. It's a little bit of a separate issue than kind of when everything interacts, because one thing that I just wanted to make sure everyone was thinking about is when someone is asking for leave as a reasonable accommodation, the real question is that leave going to allow them to perform their essential functions? And it might be, for example, if someone has a short-term need for leave because, they say they've exhausted everything else or they're not yet eligible for it. If it's a short-term leave that will allow them to heal so that they can come back to work, then that likely is a reasonable accommodation. But if it's an ongoing condition and the person, they just need more and more time off, it may not be something that's actually going to return them to their ability to perform their essential functions. And of course, accommodation that's the purpose of it, is to allow them to return to work so they can work. So gets a little bit of a sticky issue. The other thing that we're seeing quite a lot is we know that open-ended leave is not reasonable. So if someone says, I need time off, I can't tell you when I'm coming back, that's an easy one. The harder one is if the person or their provider says, we think they'll return by X date if improved, and then that date comes and that date goes. How do you manage that? So that's another area that we're seeing a lot of questions and actions on. And then the last piece of this reasonable accommodation is remote work as a reasonable accommodation. And this is, you engage in the interactive process like always. A couple of things though, because this is just coming up more and more. Think about, first of all, is the leave that, the remote work, is that really going to allow the person to perform the essential functions? And so, for example, what are the restrictions and limitations that their disability is causing? And if it's, let's say they have anxiety and they have trouble with noise, and that's why they want to work remote. Well, is there anything else you can do besides just allowing them to work from home? Can you give them headphones? Can you put them in a quiet space? So it's not necessarily something you always have to do. But if you have a connection between the restrictions and limitations and the reasonable accommodation that they're asking for, the remote work, then I think it's really important to look at comparators. So has anyone else who's not disabled been allowed to work remotely more than the hybrid schedule, or under what circumstances? So make sure that you're always, that you're not treating anyone with a disability who's asking for remote work less favorably than someone who doesn't have a disability. Okay, feel like I'm jumping all over the place, but all right, this is a really active space. Trends in meal and rest break claims. And so everyone knows what the law is in meal and rest breaks for our non-exempt employees. But there's been some new actions, a lot of class actions, sort of new arguments being made by plaintiffs' class action lawyers. And this really has to do with the timing. And so, okay, you've provided your employees a meal period of 30 minutes unpaid. That's great, but you didn't give it to them when they were supposed to get it. And they didn't get it between the second and fifth hour. They didn't get it until 2 minutes after the fifth hour of their shift. And the argument is that's a violation. And technically that is a violation. The Industrial Welfare Act says, has these very specific requirements. And so they're not getting a compliant meal period. And we're actually seeing lawsuits being filed over this. Some of the things that you can do is to make sure that for people that have scheduled meal periods, make sure they take them at the right time. There's a lot of other guidance on that too, but that would be a whole seminar in itself. But I just want to flag that issue for you. Another issue is rounding for meal periods. And so sometimes, someone will take during a week-long period, they'll take a 32-minute meal period, and then they'll take a 29-minute meal period, and then they'll take a 28, and then a 35, and at the end of the week, you say it's all good, right? It's a de minimis rule, round it. And what the argument is, and some courts are agreeing, is that the de minimis rule does not apply. They're entitled to a full 30 minutes. And so that's what they need to get. And if they're getting 28, that's a violation. All right, same thing with rest breaks in terms of the timing. The argument is that, of course, rest breaks have to be provided for every 3 consecutive hours of work. And so people that aren't getting their rest breaks within that 3-hour window, let's say they're getting it at the 3.5-hour mark because they're waiting for someone to come back on shift to relieve them, that sort of thing. Those are technical violations. So again, how do you prove? So then the issue is, how do you prove timely breaks? Because many employers, right, you don't have anybody clock out for that because it's a paid rest break. So how do we fight against this thing? And so a lot of these class action plaintiffs lawyers are asking for documentation that employees got their rest breaks when they were supposed to. And many people don't have that. Some people do. And there's a lot of debate about whether you should have that kind of documentation. And I would say it depends if you're complying. But anyway, that's another area where the argument has been you haven't documented the rest break. And if they have a client that says they didn't get the rest break in the manner they should have, in other words, within the first 3 consecutive hours, that could be a violation. So these are all kind of, new focuses. We're giving meal periods, we're giving rest breaks, and now we have to give them within these restrictions of what the regulations require. Okay, the other issue is compliance with meal and rest breaks for remote workers. So how do you do that, right? Because nobody's really monitoring these things. And, there are ways you can have check boxes on time cards, electronic or whatever, just having the person affirm that they had their compliant meal and rest breaks. There's lots of other things you can do, including educating the workers that they need to take the rest breaks, and making sure that if they are able to be scheduled rest breaks, that they are in fact, not doing work during those scheduled rest breaks. The other kind of conundrum is for this area is the intermittent break. So that's where you don't have a scheduled work break, but you take an intermittent break that equals what a rest break would. So the 10 minutes in, say, 2 or 3 minute increments where they're completely relieved from work. And the standard under the law is that it has to be equivalent to the required standards that we just talked about. And so there, it's not only that they have to get the full 10 minutes or 15 minutes, depending on your policy, but also when is it taken? And so is it good enough if they start taking their intermittent break at the 3-hour mark, or should they have completed it by the 3-hour mark? Nobody's obviously, mostly aren't keeping track of that kind of thing. But so again, it's an education, it's communication. And I think the more you push out the requirement that people comply with the technicalities of the timing, I think the better it is. Okay. All right, and now some other pay issues, and these are really pay issues that we're seeing not so much in Washington in terms of a court case or a legal requirement right now, but I think, we tend to copy each other, California and Washington. And I wouldn't be surprised if this isn't going to be where the Washington courts are going. So time rounding outside of the realm of meal periods has been the subject of litigation in California. And in 2022, the California Court of Appeals said that if you can capture the time, all that captured time has to be paid. So no rounding up to the nearest or the lowest, 10th or 15 minutes. And so I think look at your systems to make sure, if understand, are you using rounding? Are you able to capture the time paid? If you are, then I would recommend that you pay based on the actual time captured. The other area where we're seeing a lot of litigation activity, again, not yet in Washington, but I think this is on the horizon, is the pay issues for pre-shift tasks. So that's the getting ready to work. I think in other seminars we've talked about, donning and doffing, uniforms and that kind of thing. Now in this 2023, the focus is booting up computers, going through security checks, launching software to access timekeeping systems. So there, I think this what I can't remember if it was California. I'm just going to say it was which state this was, but there was a lawsuit that talked about these issues. And the normal rule is if it's de minimis, then you don't have to worry about actually paying for those pre-shift tasks. But in this case, they said de minimis was what I would think is de minimis. They said it's not de minimis. Just 2 minutes is not de minimis if the time can be calculated. And if these are tasks that were regularly performed, so having to, every morning log in and launch your software, and the overall claim when you looked at, all the people affected by it was not minuscule. And I think, I forget what the amount, it was like $30,000 if they calculated all the minutes that these people hadn't been paid over some period of time. They said that's not minuscule. And so that was enough to say you have to pay for that time. So another issue that I think is definitely going to be coming up on the horizon. And then I do have one more point that I didn't put on my slide, but it has to do with remote work and pay transparency, because I just have to talk about remote work as much as possible. So when you're in the state of Washington and you post a job, and the job is going to be a remote job, so anyone could apply for it. And let's say you also have employees in San Francisco who are performing that same job, who make higher wage rates than your Washington employees in that same job. What's the wage scale? Do you have to include the wage scale even in other geographic areas if you're hiring for the remote position, so that potentially someone who takes the job could be in California? This is not a decided question, but it's one of the many issues that I think L&I is going to have to grapple with. And so just think about that. And now I am going to pivot to some questions in just a second. I think we have several really good ones. And so I'm going to just pitch these out to the various panelists. So we had a couple questions on the independent contractors. And the first question, has to do with whether independent contractors who, if they move to Seattle, if they start off, let's say you're outside of Seattle, and then later on you move to Seattle, what do you do? Do you have to do a new contract, or how does that work?
It's a great question that the Office of Labor Standards failed to answer. So I'll do my best based on what I know. So the starting point with all this is in the Seattle Municipal Code. It says independent contractors are covered if the hiring entity knows or has reason to know that the work is performed in whole or in part in Seattle. So there's a couple of different pieces to that. In whole or in part, so any piece in Seattle, and it hinges on where the contractor is doing the work, but also looks at the hiring entity's knowledge of where that work is happening. So if the contracting relationship starts and there's no reasonable expectation that any of the work will be in Seattle, I don't think that would be covered under this. If in the middle of the contracting relationship that changes and they're doing some work in Seattle, I think that brings them under the coverage of these Seattle municipal codes. Like, I don't think you can get around it by starting somewhere else and then moving in. I would say that once that happens, you probably need to start complying with these requirements, give them the notice of rights, give them the pre-contract disclosure, which is not pre-contract anymore, but it's sort of pre-Seattle work disclosures, and then begin giving them the payment disclosures as you pay them for work that's happening in part or in whole in Seattle. So I think that's probably your safest bet, is to sort of pretend that the relationship starts anew once they're in Seattle. I don't know that you need to execute a whole new contract to start, but certainly you'll reflect that information about where they're going to be working in that the pre-contract disclosure once they start in Seattle.
Okay. And I think you might have answered this one, but so if the employer is in Yakima, and let's say, for example, and they hire remote workers who happen to live in Seattle, do they have to comply?
If those are independent contractors doing work in Seattle, then yeah, the question is where the work by the independent contractor is being performed. It really has nothing to do with where the contracting entity is based. So they could be based out of Washington, and you still need to be compliant with this if the contractors are doing some or all of their work in the Seattle area.
Okay. And then the last question on independent contractors is, let's say you're doing everything right. So you're in actuality, you're paying them correctly and you're treating them they are actually an independent contractor, but you didn't give them those disclosures. So what's the penalty? What happens?
Right, so in addition to, so obviously there's the damages issue if you're not paying them correctly, but if you are paying them, there's still the option for the Office of Labor Standards to impose fines for violations of these disclosures. The fines are detailed in the Seattle Municipal Code, but that's, you know, sort of they're all, besides damages, they can impose these civil fines for violations, and they increase as the violations continue, so. Certainly, if that's something you encounter, you want to fix it as soon as you can and then sort of work your way backwards. But that's within the purview of the Office of Labor Standards to impose those.
Okay, great. Thank you so much. We have a question about the posting for wage and salary range. And so one of the questions is, do you have to post the hiring salary range and the full range for the grade or the level that the position has? So for example, if the hiring salary range is 60 to 70, but the full grade is 50 to 80, do you have to, which one do you have to post?
Let me try to answer that question. And as a preface to answering the question, let me just sort of throw out something that many of you already, I think, know, and that is that Washington State and the city of Seattle are both consider themselves to be leaders in protecting employee rights. And we have a tendency in this state and in the city to rush through legislation which we consider to be very progressive and protective. And of course, when you look at a piece of legislation, it rarely covers every possible circumstance or fact. And instead, the legislative bodies rely upon the administrative bodies to flesh out the legislation by adopting regulations and guidelines. And even those regulations and guidelines are rarely thorough and specific enough to answer every question. And that's what the court system is really designed to do. So the courts then attempt to handle litigation about what the various statutes and ordinances really mean and how to interpret them. So now we turn to wage transparency in the state of Washington, a classic example of a piece of legislation that was rushed through. Every eventuality was not considered. The Department of Labor was left with the thankless task of trying to provide specific guidance on every single point. And as you can tell by them waiting until November 30 to issue their guidelines, they themselves were having a lot of trouble trying to figure out how to interpret and enforce the legislation itself. And I happened to go to the seminar that they conducted on the new guidelines that they were adopting. And there were a number of questions that were asked during that session, and their responses were very, very interesting. And a lot of questions applied to the salary or compensation ranges that were required. And to give you a sense of how the department is somewhat in the dark, one question was, what if I have a job and the wage is going to be the minimum wage? And that's it. So there's no range. Yet the legislation actually says you have to provide a range. So surely in that situation, I don't have to provide a range, do I? And the response was, oh, yes, you do too. So if you have a job posting and it only has one hourly rate of pay for that job posting, and let's say it's $17 an hour, you have to say $17 to $17 as your range, which I thought was ridiculous at the time. The statute certainly, could be read that way, but it doesn't feel like it should be read that way. And I'm sure that there will be litigation in the future, perhaps, years from now, in which that particular issue is before a court, and a court is going to have to decide what the legislature meant. So the same types of questions were asked about things like, well, what about ranges where we have, for example, in a union contract, it is very typical for people to start out during the first year of employment at an hourly rate of, let's say, $17 an hour, and then they gradually progress based upon seniority to higher wage rates. If we're hiring for an entry-level position, do we have to put in the rates for all of the levels of seniority under that collective bargaining agreement? And the answer was, yes, you do. So where in the actual statute does it say you must do it that way? And of course, the statute is not that specific. So we're left essentially to the authority of the administrative agency, that would say, yes, you should do that. So to be more encompassing rather than less encompassing, I think is the safe way to go, without saying that that is the absolute necessary way to go. So I think you would want to be safer. Now, while I'm on my soapbox, I'll tell you one other thing that sort of popped up that I wondered about. And that is that, they say you've got to provide this range and you have to be all inclusive and so on and so forth. But what about benefits? On benefits, they say you just have to provide a general description of benefits. And so it's okay to say we provide a 401k plan, we provide health insurance, et cetera. But suddenly, when it comes to paid time off and sick leave, they want you to itemize. So you accrue paid time off or vacation at the rate of 8 hours for every month that you work, et cetera. But what if you accrue more and more as you become more senior? Do you have to also then put the full range of accruals? The answer to that question is yes. Does the statute require that? No, it doesn't. It says you can provide a general description. So how do they make that distinction? It's one of those quandaries, that you have to deal with any new statute, like the PFMLA. It's just a new, immature statute, and there's going to be a lot of ambiguity and grayness. And sometimes that ambiguity and grayness will not be resolved until there is actually litigation about that. So
Rick, a
long-winded
related
answer.
No, that was great. I think context is really important in this situation. Sort of a corollary to that, would you recommend that someone who is going to be hiring at the starting level post the midpoint as the upper range, or would you recommend that they post the actual highest paid person in that?
I would recommend that they post the highest range. They're the highest level the employee could achieve.
Okay, great. So I think I had a question having to do with lunch breaks and the timing for lunch breaks. And that the question was, if employees can schedule their own lunch breaks, do you still have to comply with the requirement that the lunch break be scheduled between the second and fifth hour from the start of the shift, or a second lunch period if you're working 10 hours? And kind of similar to what Rick said, I think there's arguments, and my argument to that is you can waive lunch periods. Have to be paid, but you can waive them. So I don't see why you couldn't waive, the employee couldn't waive the timing of when they take their break. The question then becomes, how do you prove that they waived it versus you didn't allow them because they were too busy? And so that then gets down to the documentation issue. I don't know if any of the other panelists want to chime in on that answer.
No, I'll chime in and say I think you're exactly right, as usual. And the other thing about the statute is that it says that an employee can't work more than 5 hours without getting a lunch break. And sometimes you don't know whether the employee is going to work more than 5 hours. And you might be under the impression that they're not going to, but then the workflow changes and you do have to work longer than 5 hours. And who's to say then whether or not it would be improper to give that lunch break at the end of the 5-hour period?
Yeah. Well, I think we have exhausted the questions, and maybe you, hopefully not. We welcome any other questions you have online, or call any of us directly. We will be sending out the slides, and I'm not sure if the recording goes with it, but if you want a copy of the recording, because I do believe it was recorded, you can also ask for that. That way you get the Q&A. So thank everybody so much for coming, and Rick, I'll let you close us out.
Okay. Yes, let me echo my thanks for everyone coming as well. The next session that we'll be having will be on February 16th. And there we'll be using a format very similar to this one, except we'll be focusing on developments in federal law, and there are many of those. And in closing, I do want to say one last thing about independent contractors, and that is that Peter talked about the economic reality test that is being considered by the federal government, by the FTC. One thing to keep in mind is that in the state of Washington, the state Supreme Court, in a case involving one of the box stores, and I can't remember if it's Walmart or Fred Meyer's, actually in its decision essentially attempted to adopt that very economic reality test. So in the state of Washington, it could be argued that the economic reality test is already embedded in state court decisions, albeit not in any legislation. So that's why in the state of Washington, you have to be quite careful when you use independent contractors that you don't run afoul of that particular case. So with that, thank you for attending, and we'll see all of you in roughly a month.